I'm here to welcome Anthony Rees to our channel today. We are going to talk about the regulations of complementary medicine. Welcome, Anthony.
Thank you, Daleen.
What a mess this industry's been in for
It's
so long.
crazy. It's been a roller coaster for the last 4 years. In the end of 2013, the complementary medicines regulations were published, these controversial regulations. And towards the middle of 2014 was when the first products were called up for registration. At that point, I got really interested in how the industry was going to comply. A few stakeholders got together at a meeting which I was invited to, and we looked at the regulations as they stood, and we realized they couldn't go forward. We knew then it would be impossible for the industry to comply. I'd given up my practice at that time. I gave up my product company. I divested myself from all vested interests in the industry and decided to put myself right into the deep end of the regulatory issues.
Very brave.
Yeah, I've been following trends in regulations for probably 20 years now. I was involved in one of the first health freedom organizations back in 1996 to 98.
But you're talking internationally as well, though.
That's right.
Your research.
And I went to Canada for a stint, and I assisted the Canadians in looking at new regulations that were coming in their country in the beginning of 2000, 2001, which were equally draconian. So I assisted them there. I got a lot of knowledge on how to fight back, how to, look at the regulations more objectively. And coming back to South Africa, I felt it was my time to roll up the sleeves, so to speak,
and to
say
share
no.
what you've learned.
Yeah, absolutely.
Well done.
Thank you.
Well done. I think we're all, as an industry, incredibly grateful.
One of the most difficult things about the regulatory framework that we have in front of us is that it's like spaghetti all over the place. One section will talk to another, and it's very difficult to understand. It's very ambiguous how these regulations have been written, and you have to really be a trained regulatory pharmacist or somebody that's trained in law to understand them. They've almost been written in such a way that they're impossible to even understand in the first place, to put companies off even.
Absolutely. I mean, an industry advertiser of mine would have a problem with complying to regulations, not even talking about the cost to comply, but where they're storing the products, the pharmacist on board, relabeling everything, having, a lawyer that they need to pay to make sure that all their dossiers are filed.
That's
and
right.
I believe that when it was filed and piles and piles and piles of documents arrived at the Medical Control Council in time at a huge cost, it was lost, right?
This happens, and we've heard numerous instances of where this occurs. If you look at the registration submissions, the paperwork that's involved to register a product or to have it assessed for registration, let's put it that way, it's probably 2,000 pages, reams and reams and reams of paperwork. Much of this paperwork is not even necessary. It's not applicable to this industry. It's applicable to high-risk pharmaceutical drugs, but it's been superimposed over the natural health products regulations. That's where the problem is. The cost of compliance is not just building the factory, which is going to cost you 25 million up. The cost of compliance is hiring regulatory pharmacists to look at your paperwork, to draft your paperwork, to sign off on your paperwork, because the Medicines Control Council, or what will now be called the SAHPRA, is requiring pharmacists to be the people who sign off. You also have to have pharmacists employed full-time in the production of the products. If you're a retailer, it looks like in the future you might need a pharmacist if you're retailing as well.
You have a whole regulatory department that just looks at an advert.
That's right.
To make sure you're not making claims.
And because a lot of these products will be scheduled by nature of the way the regulations are written, health stores too will have to hire pharmacists and become a pharmacy to sell what they currently sell on the shelves.
Isn't it crazy?
It's crazy. We have a huge deficit of pharmacists in this country. Latest statistics released by the pharmaceutical industry themselves up to a month ago showed that we have 12,000 pharmacists short. We are 12,000 pharmacists short just to keep the wheels rolling in the pharmaceutical
because
industry
they
alone.
left in the 90s.
Many of them
when
left
that
to other
whole,
countries. Yeah.
issue was with government regulating prices.
Yeah. And like doctors and like nurses, many of them get poached by overseas countries as soon as they finish their qualifications. So there's a huge brain drain.
Right. So tell me, where are we now?
The regulatory hurdles are so high that not a single company in South Africa, I believe, that's involved exclusively in natural products will be able to put an application forward and be successful to register a product. And that's where we sit at the moment.
Mm-hmm.
And over the last 3 years, we've seen successive regulatory amendments come forward that have tightened it even more.
Mm-hmm.
There's definitely going to have to be a legal challenge to these regulations, as well as social mobilization of consumers and patients and users of these products. If we don't, the time is coming where these products are going to be removed from the market. We know that up to 95% of natural health products that currently sit on the shelves of health stores, pharmacies, etc., are going to be removed from the market if we don't fight back. So the industry...
This will just sort of happen.
What will happen is that the products will be called up successively. Companies will not have registration as manufacturers themselves. They might not have the paperwork and licensing in place to retail, etc. So you're going to have a whole cascading effect of products disappearing from the market. Direct marketing companies are going to be completely wiped out.
Mm-hmm.
So, a lot of people who use direct marketing in South Africa are people who are sole breadwinners at home.
Sure.
And there's 50,000 people in South Africa who
it's a
sell
very,
products
very
through
large
direct marketing.
industry.
Yes.
And if you look at your health shops, they're probably going to end up being health food stores.
Well, they'll have to go back to selling, nuts and Dr. Scholl sandals at the end of the day, unless they adapt. We've seen other countries where repressive regulation like this has been imposed. In Europe, for instance, health stores have completely changed or disappeared. The mom and pop health store in England has disappeared. In other parts of the EU, they've completely disappeared. You get large chains of health stores that are left, and they're selling, your general low potency multivitamins and things like that. It's not the health store we know today.
I think I've heard you say so many times that, it's time to stop sitting passively and wait for someone to act.
For the last 3 years, we've been very, very active. We've been engaging with the regulator through correspondence, through face-to-face meetings. We've also been to Parliament as an organisation. We're lobbying public representatives. We've also appeared before committees in Parliament to talk about the issue.
And you're bringing the traditional African healers into the conversations as well.
We're sitting on the last continent in the world where their traditional medicine of the continent hasn't been brought to the world. If you think Chinese medicine, Ayurvedic medicine, North American herbal medicine, all these things, and European herbal medicine, they've flourished and they've become worldwide commodities. African traditional medicines have not. And they are the last form of traditional medicine that hasn't reached the world. These regulations will stop that. Any innovation of natural health products for indigenous flora that could be potentially used around the world as complementary medicines in their own right on the shelves alongside other traditions, that will not happen with
that
these
for me is one of the saddest issues. So you need funding, right?
We obviously need funding. We run on a very tight budget. We have our lobbying work. We have our full-time office, which we run to deal with this specific issue. We also need funding to get into social media to start waking up the public to this issue, because at the end of the day, people are going to lose their right to choose these types of products. That choice that we've built in the last 30 years in South Africa now can just be taken away at a whim. And that's what we have to fight for.
We'll be very active in sharing your Facebook posts, the TNHA's Facebook posts. Please also like the page.
Thank you.
Put your comments there. You're going to put some innovative funding mechanisms onto Facebook, and we're doing a GoFundMe page.
Thank you.
But I think we all want to know. Everyone, let's get up. Let's join the fight. How good is your chance of winning this?
Well,
what merit
we
do you have?
We cannot do it alone, and that's why we're working with different organizations in South Africa who have a similar vision.
Is there anything that you can tell us without giving too much away of your most significant points that you feel is the strongest points that would give us a win here and redraft the regulations?
Sure. There are literally hundreds of points that we've put together, but we've had to kind of put them on a scale of most relevant down to the bottom. And it's been a frustrating process because everybody wants to put their point across. But we've got a few cardinal pillars of our strategy. I can't discuss them in any great detail because it hasn't been finalized. But the main thing is these products that are on the market today, they are not drugs. The Medicines Act was published and gazetted in 1965. It's a piece of legislation that's over 50 years old.
It's draconian.
Yes, and even though there have been modernization amendments to the Act, they've been for the pharmaceutical industry, not for this industry. And we're going to have to challenge the jurisdiction of the Act over these products, because when the Act was originally brought out into being in 1965, it was called the Drugs Control Act. And it was meant specifically and exclusively for novel patent drugs that came onto the market. After the thalidomide tragedy, that's what brought regulators around the world to quickly bring out regulations to protect the public from a lot of unsafe chemicals that were being sold on the market without any regulation. And the Australians were the first to bring out regulations and legislation to protect the public from these new novel chemical-made drugs. South Africa, in fact, was the second country in the world, 3 months later, to bring out a legislation to do exactly that. So the Act was there to protect the public from new substances, not natural substances that appeared in nature.
So that's part of your angle.
It is one. And up until recently, up until 2014, the Medicines Control Council had not put an exclusive clause to define these products in the Medicines Act through all the amendments. They attempted to in 2014 with an amendment bill. The first drafts of the amendment bill included complementary medicines in Section 1, which defines all the different things within the Act. We went to Parliament as an organisation, we protested against that, and we were successful in having the complementary medicines definition removed from the Act. We believed at that time the people in Parliament had applied their mind correctly. They realised these products were not supposed to be within the Act. But after 2014, the Medicines Control Council came up with a completely new story, saying that, well, a medicine is a medicine is a medicine, and therefore it has to be registered. So these things are going to have to be tested in a court of law.
It's time.
There's other issues. I mean,
you want to tell me more? Come on.
Sure. Like, for instance, African traditional medicine, which is used by 80% of our population as their primary medicine. Before going to clinics and hospitals, they use traditional medicines. They're not being regulated at all.
They're not being recognised.
Or recognised for that matter. And it is unfair, and in terms of the equality clause of the Constitution, which guarantees equality, you can't regulate one set of traditional medicines from a Chinese tradition or a Western tradition or an Ayurvedic tradition, but leave out the biggest one in South Africa, which is African traditional medicine. It doesn't make any sense at all.
I'm here to support you in any way I can, and really all the very best. And I can't wait to have you back with some good news once you've filed and once you're able to give us some more information on the points that we can all get behind.
We will do. You will be hearing from us within the next week or two. Things are going to start happening very quickly.
And we'll have you back.
Yes, you will.
Thank you.
Thank you.